Well, good afternoon, everyone. Welcome to Samfiru Tumarkin live stream. My name is Sandy Chen. I'm an employment lawyer here at our Vancouver office. So hopefully we can answer some of your questions today. I do want to. I do want questions. This is the purpose of our live stream. So please feel free to pop in anytime. Once again, I deal with workplace issues. It's a reality of life. While nobody wants these types of issues, I'm sure that it comes up at least once or twice, whether there's harassment or in the workplace, or you're having issues with your boss, or if you've been let go, or if you're just not getting paid overtime. Any issues like that, please feel free to bring up your questions. As I said, I deal with these issues on a day-to-day basis, so I will look for your questions on my prompt box here. And just so everyone knows, we do also have a website with a lot of great information. It's called employmentlawyer.ca. So if I can't answer today, please do go on the website and check it out. You can also feel free to email me anytime. My email is sandy.chen@stlawyers.ca. So I had a few topics I wanted to talk about today, but I see we do have a question from Loretta. So Loretta's asking, can my employer send me home until I am fully vaccinated? So Loretta, that's a great question. And the answer is, it depends on the workplace, right? The employer has an obligation to create a safe workplace for employees. The issue is it depends on where you're working, right? If you're in an office environment and there's been no COVID cases, and there's a very low chance of the virus spreading, then probably not. If you're in one of the cases I'm thinking of is meat processing plants. So COVID was prevalent in those types of plants throughout the last year. That's a different type of workplace where it might be reasonable for the employer to send you home until you're fully vaccinated. Now, to be clear, your employer can't force you to get the vaccine. If they can't discipline you for not getting the vaccine. So I hope that answers your question. If you give me some more details on the type of workplace you're in, and let me know if they're paying you as well, because that's obviously a big factor. If they're just saying go home, we're not going to pay you, depending on your workplace, that's probably not going to be allowed. Okay, Laura. So yeah, I mean, let me know. I'm happy to chat afterwards too. Like I said, I hope my contact information should be on the screen there, hopefully, and you can feel free to contact me afterwards, and I'm happy to chat further about it. So let's talk about something that nobody wants to talk about. I wanted to chat about termination meetings because a lot of my clients that have come in have just had their termination meetings. And one of the things that, and these are things that I wish people knew going into termination meetings. Sometimes they're expected, sometimes they're not. So let's talk. I just want to give some general guidance on these types of meetings so that people know what will typically happen and what to do and what not to do. And that way, maybe when you come talk to me, we've set your case up better. So number one, there's two types of termination meetings generally. And the first is called a just cause termination meeting. And you'll find out in the meeting which type it is. So there's just cause. There's a just cause termination meeting and a without cause termination meeting. just cause essentially means that your employer has said that you've done something wrong to warrant a termination. Whether it's the fact that they're saying you had performance issues, or if you engage in some sort of misconduct, time theft, stuff like that. The HR person or the manager you're meeting with will make it clear in the meeting whether they're saying you've been let go for cause or without cause. So that's number one. The significance of that is that if you're being let go for cause, they're entitled to not pay you any severance. So that's why employers sometimes say, well, Mr. Smith, employee, you've done something wrong. We're not going to pay you any severance. So without cause is meaning, you didn't do anything wrong, but for, let's say, business reasons, we're going to have to let you go. So you'll know pretty quickly during the termination meeting whether it's for cause or without cause. And this is one key point that I want to emphasize to people. If you've been let go for cause, just because the company says it's cause doesn't mean. So I see a question from Dan. So what can I do if the employer tells me it's for cause? So just because the company says it's for cause doesn't mean that is the case. I assure you that hundreds, if not thousands of cases have gone to the courts, and the court will disagree with the employer and say, that's not cause, right? So for example, you are a salesperson, you didn't hit target for a few months, and your employer says, well, you didn't hit target for 3 months, we're going to let you go for cause. In that example, courts have consistently disagreed and said that that's not cause. So I think that's number one. Just because your manager or HR in the meeting tells you that, we're letting you go for cause, you screwed up, doesn't mean that that's the case. And so I would strongly urge you to seek an employment lawyer if you're ever put into that situation. And the unfortunate reality is sometimes companies say it's cause just, and I'm not, it's hopefully it doesn't happen that often, but I've certainly seen cases where companies might say it's cause just to avoid paying severance, right? So I think it's really important for people to, if you've been let go for cause, especially to seek some legal advice, and an employment lawyer should be able to tell you with some degree of certainty whether what you've done or did not do is cause at law. So that's the first type of termination. The second type is without cause, right? So you would be entitled to a severance package. And so Francis asked the question, if we are called into a termination meeting, should we ask for more time and seek legal advice? Yes. So Francis, that's a great question. So if you're being terminated for cause, definitely go seek legal advice. If it's without cause, typically what happens is they'll hand you some paperwork. They'll say, sorry, Mr. Employee, we're going to have to let you go. Here's a severance package. And the severance package, most of the times in my experience, isn't what you're fully entitled to at law. I have had cases where the manager or the HR person will say, hey, you need to sign this now or we're not going to pay you anything, right? They can't do that. You can always insist on getting more time or asking for an extension of time to go seek legal advice. So whether it's for cause or without cause, general advice, don't sign anything on the spot. Go and seek legal advice on whether the severance package is sufficient. Most of the times, it's likely not. And it might not be out of any malintent on the side of the employer. There's websites out there saying 1 week per year of service, right? And so maybe the HR person Googled it and they thought it's 1 week per year of service, up to 8 weeks. A lot of employers don't know about what's called common law notice. So Common law notice, general rule of thumb, it's more 3 or 4 weeks per year of service, and up to a maximum of 24 or 26 months. So I think it's whatever reason you're being let go, I would say it's always worth going to seek, that half an hour or an hour of legal advice just to see if there's any more you can do. So yes, you should ask for more time to speak with a lawyer. Okay, so we've got more questions here. We are being forced to work overtime without pay, even on weekends. If we do not do our review, we got no bonus. And no, so the question is, we're being forced to work overtime without pay, even on weekends. If we do not, our review is bad. They can't do that. Okay, if you work more than 40 hours a week, you're generally entitled to overtime, right? If you're working 80 hours a week, you're entitled to 80 hours of pay, and 40 generally. And I say generally because some employees are exempt, but generally speaking, you're entitled to a time and a half for any hours over 40 that you work. So no, you can't. That sounds like that it's a potential complaint to the labor board. Unless, even if you're on salary, unless you're fall under one of the exemptions, you're still entitled to overtime. So I think that's from or top 99. I hope that answers your question. So more questions. I like it. So two employees started 2 years ago and they're always late. A few times I came. So a question from Frank. New employees started 2 years ago. They're always late. The few times I came in late, I got a warning. I think they're trying to. I don't want to make any presumptions, but if they're inconsistently applying that disciplinary policy, it sounds like they might be targeting you. I don't know why that is, but Frank, if you get let go for the lateness issue, I can tell you now, if they don't consistently apply their policies and discipline all the other employees that are always late, they're going to have a hard time doing that to you. They're going to have a hard time terminating you for cause. And that's something that judges frown upon, right? Is you're targeting one employee, you're issuing warnings to someone who's late, and you're not doing anything to the other employees. But I would keep records, Frank, and just make sure that, day X, one of your colleagues was late, no discipline, right? Keep records of that, because I think that'll help in case they do ever let you go. I mean, obviously, let's hope not, but if you have records of the days the other people were late, and they weren't disciplined, and then you're ultimately let go for being late, those records will help. So Razor Sharp. I am working for a US-based magazine company, but I work out of Ontario. My employer works out of Vegas. What rights do I have? So Razor, I need to know more. Generally, if you're physically in Ontario, employment laws of Ontario will apply to you. The one during these times, there's been some, obviously people are moving all over the place, right? Working remotely. My question for you is, were you working out of Vegas before? And did you just move to Ontario for COVID? Or were you always in Ontario, just physically working there because that's what your employment contract says? There's a difference, because if you were just in Ontario for COVID, if you're working remotely, then it's a different story. Okay, so I've always worked in Ontario. Okay, so to Razor Sharp, it's very likely you're going to be based on Ontario laws, right? And you be entitled to all the protections of Ontario employment laws. I don't know Las Vegas employment laws. Maybe they're more favorable. Maybe they're not. But generally speaking, my understanding is the U.S. Some states are less favorable. I don't know about Nevada, but yeah, it's likely you are covered by Ontario employment laws. Okay, so I can't seem to scroll to get some of the other questions, but I will try to get to these ones that I missed. Okay, so razor strap, you say it's at will there. Employment says, yeah, I would speak to an employment lawyer. It's certainly not at will in Ontario. So if you've always been in Ontario, your contract says you're working out of Ontario. They can't rely on Nevada laws, the at will laws down there. So especially if you're a long-term employee, it could be quite a bit of money that they might owe you for severance. So I do apologize. I can't seem to scroll down to get to the other questions here. Okay, if you had a question, I missed it. If you could just resend it, and I'll do my best to answer. So yeah, I mean, so termination meetings, I know it sounds kind of like general guidance, but and it is an emotional time, but generally try to keep your cool during the meeting, because you'd be surprised at what the company might try to use against you if you start yelling or start swearing and all that stuff. I know it's easier said than done, but it is one of those things where you do want to try to keep your cool. One of the questions I get asked is, should I record my termination meeting? And like all legal questions, there's no general, there's no one size fits all. So if it's without cause, right? The employer isn't saying you did anything wrong. There's generally no point in recording it. And I should start off by saying, for any employment, if you're an employee and you want to record a conversation, it's not illegal. If you're part of the conversation, right? You can't secretly record a conversation between your boss and the president or the CEO or whatever, because you're not part of that conversation. If you feel like the termination meeting is going to get a lot of conflict and they might throw accusations at you, and one particular scenario where if you think they're letting you go for a discriminatory reason, so they're letting you go because of your race or your gender or your disability, it might not be a bad idea to record that termination meeting. And because that will serve as evidence in the Human Rights Tribunal or at court. So just be aware that it's not always a good idea to secretly record. I would definitely talk to an employment lawyer before you do that, especially if you see that something's coming, like a disciplinary meeting or a termination meeting. So I've got a question from Denise here. So Denise asks, can I use text messages as form of proof for misuse or abuse at work? Absolutely you can. I mean, that's much better than a he said she said situation. If you have texts from your boss or from a colleague that are that constitute harassment or just verbal abuse, that's one of the best types of evidence that you can use. Much better than she said this and then he said this. So absolutely. Okay, if nobody else has any questions, I'll continue with today's topic of termination meetings. So in terms of the recordings, the one thing I'll say is be very careful, because if you record your boss secretly at a meeting and it comes out in court that you recorded them secretly, that could be seen as insubordination and a loss of trust in you. So it can actually be used against you in court, the fact that you secretly recorded something at work. So my general advice is, if you think that it absolutely needs to be recorded because they're just going to lie about the conversation, sure, do it, but make sure it's for a very good reason, or else a court will not. It will frown upon the fact that you did it, although technically it's not illegal. Just because it's not illegal, though, doesn't mean that you should do it, obviously. So be very careful with recordings. Frankly, a lot of the times, if you record a termination meeting, it doesn't really even help the case. So a lot of the times, there's no point in doing it. If you see a termination meeting coming and it's something that's you're expecting, talk to an employment lawyer to see whether you should record it or not. And I'm not going to say it never helps, because I've certainly had cases where the termination recording, the meeting, the recording of the meeting, absolutely was vital to the case. So it can help in some situations. And so I think one of the last points I'll make about these termination meetings is, sometimes you'll get the sense that, if you don't sign this piece of paper, that you're breaking the rules, or they're not going to give you, any money. I'll quickly outline some things they have to do, regardless of whether you sign anything or not. Because I've heard some stories where employers will say, we're not going to issue your record of employment unless you sign this, right? They can't do that. That's almost a basis for acting in bad faith. Obviously, when you're let go, you need that record of employment to apply for EI. That's very important to you. And I just don't want people to feel like they're being bullied into signing something. So even if you don't sign anything, they have to issue a record of employment within, I think it's 5 days. They have to issue it by. So that you don't have to sign anything to get that. Another common one is termination pay. If you're let go, they have to give you the minimum under the Employment Standards Act in BC, right? Other provinces might be different, but in BC, and I know for Ontario, they have to pay you your termination pay it's generally a week per year of service. Within, I think it's 48 hours that they have to pay you. So there's a prescribed minimum by law that they have to pay you after you've been let go. The key point here is, the key word is minimum, right? So let's say, I don't know, you're a 20-year employee, you've been let go without cause, right? And let's say you're a bit older, you're in your 60s. You could be entitled to up to 24 months of pay at common law. Where when I say minimums, I mean they have to give you what's prescribed, what the government has said they have to give you, right? So in that example, you would get at least 8 weeks, but you could be entitled up to 24 months. So just be aware of that. The bottom line is, once you've been let go, there's a certain amount of termination pay they have to pay you, regardless of whether you sign anything. So that's another thing the employer has to do, without you, just by virtue of your termination. Other things that are fairly common is, vacation pay, any vacation pay you haven't used, any wages, right? So all the money you've earned, any commission pay if you're working in sales, they have to give all this to you. You don't have to sign anything. And if you feel to the earlier question of, can I ask more time? You should absolutely ask for more time. And it is, if they're forcing you to sign on the spot or pressuring you to sign on the spot, then your guard should be up and you should be a bit suspicious, because it's likely that they're not offering everything that you should be getting at law. So that's all I want to talk about termination meetings. Hopefully that gives people some guidance. I think the main lesson, and this is just talking from experience, from talking to people that have called in, don't feel pressured. They're going to give you paperwork. You're absolutely entitled to ask for more time. The paperwork's going to be all legalese, so you might not understand a lot of it, and you need time to process it. So please don't feel pressured during the termination meetings. Take the paperwork, walk out, call an employment lawyer, get some advice. So Francis asks, in the termination meeting, are they supposed to accept the money, or can I deny and seek legal advice? Yeah, that's a great question, Francis. So if you're being let go, what typically happens is they'll say, are we, okay, yeah, so gotcha. What typically happens is they'll say, Mr. Smith, you're being let go today. Here is 4 weeks pay. And if you sign this piece of paper saying you won't sue us, we're going to give you another 4 weeks pay. Something along those lines. I mean, the number varies, obviously, depending on the person in the company, but something along those lines. What I would typically suggest is that you take their offer, you say, thank you for the offer, I appreciate it. I just need time to process this, and I'll get back to you within a week or two. And then you take whatever severance package or papers that they give you, and you get that reviewed, because what they want you to sign essentially says, it's called a release. It essentially says that in consideration, by accepting our money, I am giving up my legal right to sue. So that's probably something that you should not sign if you do want to pursue additional severance. I mean, look, there's cases where people get offered a really good package, right? But if you want that peace of mind, I mean, you should get it reviewed, but again, it's depending on the person, right? So Francis, the follow-up question: take the paper unsigned. Yeah, so just you'll take it. They'll give you a form, and you'll just say, hey, yeah, you'll just say, thank you for the form. I need time to process this. Don't sign anything, and seek legal advice on it. So I hope that answers your question, Francis. And please feel free to follow up if I wasn't clear about anything. So another question by CKNI. I was terminated by a company due to loss of an acquisition for which the company was created. So it sounds like you were let go because an acquisition didn't go through. I'm sorry, CK, if you could just clarify that question. I'm not sure. So what was the reason they let you go? If it was because an acquisition fell through, that doesn't have any bearing on your severance. If you're letting someone go for business reasons, right, because a deal fell through, you're still entitled to severance. As for your question of, what severance I should get, that is a question that depends on quite a few factors. Someone in their 60s should get more than someone in their 20s. Someone who's been with a company 40 years should get more severance than someone who's been with a company 4 months. So the biggest factors are age, length of service, your position, the availability of comparable employment. These are all, and look, I've seen severance packages ranging from a week to 24 months. It's a huge range, and it depends on a whole lot of factors, right? If you're 65 years old, you've been with a company for 40 years, you should be getting close, if not 24 months. And I would encourage you to reach out or go on our website, and we do have a calculator that you could use to get a rough approximation. Obviously, the best way is just to speak with an employment lawyer, but hopefully that helps you a little bit. All right, guys. So if there's any more questions, please ask now. I know we're nearing the end of our time, but I'm happy to stick around for a bit if anybody else has any questions. But I hope the takeaway today is if you've been called to a termination meeting, don't feel pressured. You have time. If you're handed paperwork, don't feel pressured to sign it. They can't force you to sign it. And I always suggest to go get legal advice before signing anything, because you could be signing away an opportunity to perhaps, get a better severance package. All right. Well, thank you, everyone, for joining us. I hope everybody got the answers that they were looking for. Again, please feel to reach out to me anytime. It's I'm always happy to chat, and my information should be on the screen there, I hope. But yeah, I will thank you guys for joining us, and I hope everybody has a lovely weekend and enjoy the very pleasant weather we've been having now that the heat wave's over.